Don't sit there like you're in charge. This isn't your courtroom.
You are inside my home without a warrant. You are breaking federal law.
You think that title scares me? I don't care.
The dinner table was set for 4. Candles flickered against wine glasses. Laughter echoed through the dining room of the modest brick home on Sykenham Avenue. Judge Diane Forrester had just finished telling a story about her grandson's first day of kindergarten when the pounding started. Not knocking, pounding. The kind that makes your chest tighten and your hands freeze mid-gesture. 3 ICE agents were about to make the worst decision of their careers, and they had no idea that the woman reaching for her napkin held the power to dismantle everything they thought they knew about authority. The force of the banging rattled the front door in its frame. Judge Forrester's dinner guests, her sister Carolyn and 2 colleagues from the courthouse, went silent. The kind of silence where you can hear your own pulse. Another series of thunderous knocks shook the house. A voice boomed from outside. "Federal agents, open the door now." Judge Forrester stood slowly, her chair scraping against hardwood. She walked to the foyer with measured steps, her 23 years on the federal bench evident in her composure. Through the peephole, she saw 3 men in tactical vests with ice patches visible under the porch light. She opened the door partially, the chain lock still engaged. "Can I help you?" Her voice was calm, but carried weight. The lead agent, a man named Vincent Kozlowski, with 15 years in immigration enforcement, didn't answer her question. He demanded to know if Maria Sandoval was inside the residence. Judge Forrester asked who was asking and under what authority. Kozlowski's jaw tightened. He said they had information that an undocumented individual was inside and they were conducting an enforcement operation. Judge Forrester asked to see the warrant. That's when everything accelerated in the worst possible direction. Kozlowski said they didn't need a warrant for this type of operation. Judge Forrester, a federal judge who had presided over countless immigration cases, knew that was categorically false. She told them they absolutely needed a warrant to enter a private residence without consent. Kozlowski's face flushed. He said they had exigent circumstances. Judge Forrester asked him to articulate those circumstances. The agent behind Kozlowski, a younger officer named Troy Bannister, stepped forward and said they didn't have time for this. They had credible intelligence that their target was inside and fleeing. Judge Forrester looked past them. No one was fleeing. Her block was quiet. Porch lights glowed from neighboring homes. A cat wandered across a lawn 2 houses down. She told them again, clearly and slowly, that without a warrant, they could not enter. Kozlowski made a choice. He signaled to the third agent, Ramon Gutierrez, who moved toward the door. Judge Forrester attempted to close it, but Gutierrez wedged his boot in the gap. Kozlowski announced they were coming in under federal authority. Judge Forrester raised her voice for the first time, commanding them to stop, identifying herself as a federal judge and informing them they were violating the Fourth Amendment. Kozlowski laughed, actually laughed. He said if she was really a judge, she'd know they had authority here. The chain lock snapped. 3 agents pushed into Judge Forrester's home. Carolyn screamed from the dining room. The 2 courthouse colleagues stood frozen as armed men in tactical gear stormed through the foyer. Judge Forrester demanded they leave immediately. Kozlowski ignored her completely, directing Bannister to check upstairs and Gutierrez to clear the first floor. Judge Forrester followed Kozlowski, her voice sharp and steady despite the violation unfolding in real time. She repeated her identity. She demanded supervisor contact. She informed them every action was illegal. Kozlowski told her to step back or she'd be charged with obstruction. That's when he grabbed her arm. A federal judge, in her own home, during a private dinner, without a warrant, without cause, without even confirming her identity. Judge Forrester jerked her arm away and told him not to touch her. Kozlowski's hand went to his hip, resting on his service weapon. The implied threat was unmistakable. Bannister came downstairs announcing the second floor was clear. Gutierrez emerged from the kitchen shaking his head. No one matching their target description was present. Because Maria Sandoval wasn't there. Had never been there. The intelligence was wrong, outdated, or possibly fabricated. But instead of apologizing and leaving, Kozlowski demanded identification from everyone in the house. Judge Forrester's colleagues produced their credentials, both attorneys who worked in the federal courthouse. Carolyn showed her driver's license with shaking hands. Judge Forrester walked to the entryway table, retrieved her judicial identification, and held it directly in front of Kozlowski's face. The color drained from his features. His mouth opened slightly. No words came out. Bannister looked over his shoulder and muttered something that sounded like a prayer or a curse. Gutierrez took 2 steps backward. The atmosphere shifted instantly. Kozlowski's aggressive posture collapsed into something resembling panic. He stammered an attempted explanation, saying they were following up on solid intelligence, that this was a routine enforcement action, that there must have been some miscommunication. Judge Forrester cut him off. She informed him that he and his team had just committed multiple federal violations, including unlawful entry, assault on a federal officer, and civil rights violations. She told them to leave her home immediately and that she would be filing a formal complaint with their superiors at the Immigration and Customs Enforcement Office of Professional Responsibility before the night was over. Kozlowski tried to salvage the situation. He suggested they could all sit down and discuss this calmly, that perhaps there was a misunderstanding that could be resolved. Judge Forrester's response was ice. She told them the only thing they needed to understand was the location of her front door and how quickly they could walk through it. The 3 agents left, but the damage was done. The violation was complete. The consequences were now inevitable and unstoppable. The moment the door closed, Judge Forrester called the federal courthouse emergency line. She detailed everything in precise chronological order. The pounding on her door, the refusal to show a warrant, the forced entry, the physical contact, the implicit threat, the ransacking of her private residence, all of it captured in her methodical recounting. The duty officer on the line went silent for a long moment before asking her to repeat her name and title. When she did, the officer said he would escalate this immediately to the chief judge and the U.S. Marshal Service. Within 30 minutes, 3 separate entities had been notified: the chief judge of the Federal District Court, the U.S. Marshal Service, and the Department of Homeland Security Inspector General. By midnight, preliminary reports were being drafted. By morning, the story would break in ways that would genhan the entire federal law enforcement community. But Judge Forrester wasn't finished. She spent 2 hours that night documenting every detail while her memory was fresh. She noted the time of the initial pounding, the exact words spoken, the physical descriptions of each agent, the badge numbers she'd glimpsed, the sequence of their movements through her home. The location where Kozlowski had grabbed her arm, leaving a faint red mark, she photographed immediately. Her colleagues offered to stay, but she sent them home. Carolyn remained, sitting in the kitchen drinking tea that had gone cold, still shaking from watching armed agents invade her sister's home. Judge Forrester worked at her dining room table, the same table where 30 minutes earlier she'd been laughing about her grandson. The candles had burned down to stubs. The wine sat untouched. The meal was ruined. But the documentation was thorough, methodical, and devastating. What Kozlowski, Bannister, and Gutierrez didn't know as they drove away from Sycamore Avenue that night was that they hadn't just violated procedure. They hadn't simply made a mistake that would result in a reprimand or additional training. They had assaulted a federal judge in her home without legal authority, creating a constitutional crisis that would reverberate through multiple agencies and end careers in spectacular fashion. The intelligence they'd relied on? It would later be revealed as completely fabricated, based on an anonymous tip that was never verified, never corroborated, and should never have justified any action whatsoever. But that revelation was still hours away. For now, 3 ICE agents believed they'd simply had an unfortunate encounter that would blow over. They had no concept of what was coming. No understanding that by morning, their names would be on reports circulating through the highest levels of federal law enforcement. No idea that the woman whose arm Kozlowski had grabbed would become the catalyst for the most significant immigration enforcement scandal in recent history. Morning arrived with the force of a detonation. By 6 a.m., the Inspector General's emergency response team had assembled in a conference room 3 states away. By 7, the U.S. Marshal Service had agents en route to interview Judge Forrester. By 8, the Chief Judge had convened an emergency judicial council meeting, and by 9, Director Samuel Keaton of ICE was sitting in his office staring at a preliminary report that made his blood run cold. 3 agents, 1 federal judge, 0 legal justification. The mathematics of the disaster were brutally simple. Keaton had been with immigration enforcement for 23 years. He'd navigated budget crises, policy changes, administration transitions, and countless controversies. But this was different. This wasn't a policy disagreement or a political battle. This was armed federal agents forcing their way into a sitting judge's home based on intelligence so flimsy it wouldn't have justified a phone call, let alone a raid. He picked up his phone and made the call he'd been dreading. Within 90 seconds, he was connected to the Attorney General's office. The conversation lasted 4 minutes. Keaton did very little talking. Mostly, he listened as a voice explained in precise legal terms exactly how catastrophic this situation was and what would happen next. The agents were to be suspended immediately. Full investigation with outside oversight. Complete audit of the intelligence that led to the operation. Review of every case the 3 agents had worked in the past 2 years. And personal apologies from the highest levels of the department to Judge Forrester. That last part stuck in Keaton's throat. Not because he disagreed, but because he knew an apology would mean absolutely nothing at this point. You don't apologize your way out of constitutional violations. Across town, Kozlowski was eating breakfast when his phone rang. The voice on the other end told him to report to headquarters immediately and bring his badge and service weapon. No explanation, no discussion, just the order and a dial tone. Bannister got the same call while dropping his daughter at school. Gutierrez received hers in the middle of a workout at the gym. Within 2 hours, all 3 were sitting in separate interrogation rooms. The same kind they'd sat suspects in countless times before. The irony wasn't lost on anyone. The interviews were methodical and devastating. Each agent was walked through the previous night step by step. What intelligence had they received? A single anonymous tip called into a hotline. Had it been verified? No. Had they attempted to verify it? No. Had they obtained a warrant? No. Had they consulted with legal counsel before proceeding? No. Had they identified themselves properly at the door? Debatable. Had they forced entry after being denied? Yes. Had they made physical contact with the resident? Yes. The interviewer, a woman named Special Agent Victoria Rains from the Inspector General's office, had the kind of calm demeanor that made everything worse. She wasn't angry, she wasn't emotional. She simply documented each answer with the precision of someone building an airtight case. When Kozlowski tried to explain that the woman had been uncooperative, Rains stopped him mid-sentence. She slid a photograph across the table. It showed Judge Forrester in her judicial robes at a naturalization ceremony, swearing in new citizens. Kozlowski stared at it, his face draining of color as understanding finally crashed over him. Rains let the silence stretch. Then she asked if he'd bothered to run the address through any database before executing the operation. He hadn't. If he'd simply entered the street address into the federal property registry, it would have flagged immediately as a federal judge's residence, triggering automatic protocols that would have prevented everything that followed. But he hadn't checked. None of them had. They'd received a tip, made assumptions, and acted. Bannister's interview went similarly. Gutierrez's was worse because he'd been the one physically searching the home, rifling through personal belongings without legal authority. Rains asked him what he'd been looking for. He couldn't answer clearly because there had been no specific target, just a vague directive to find evidence of illegal presence. Evidence of illegal presence in the home of a woman born in Philadelphia who'd served as a federal prosecutor before being appointed to the bench. The absurdity would have been comedic if the consequences weren't so severe. By noon, all 3 agents were officially suspended without pay, pending the outcome of the investigation. Their credentials were confiscated, their access to systems revoked, their lockers cleared. 24 hours earlier, they'd been federal agents with authority and power. Now they were subjects of a criminal investigation, with lawyers telling them to remain silent. The media got wind of the story by early afternoon. The initial reports were careful, citing unnamed sources about an incident involving immigration enforcement and a federal official. But by evening, Judge Forrester's name was public. By the next morning, it was the lead story on every major news outlet. The details were explosive. Armed agents, no warrant, forced entry, physical contact. And the victim wasn't some random citizen, but a federal judge who dedicated her career to upholding the law they'd so spectacularly violated. Legal experts lined up to offer commentary, and their assessments were uniformly damning. Fourth Amendment violations, potential assault charges, civil rights violations, abuse of authority. The list went on. Several pointed out that if ordinary citizens had forced their way into someone's home, grabbed them, and ransacked their belongings, they'd be facing serious felony charges. The fact that these were federal agents made it worse, not better. Judge Forrester gave one statement through her attorney. It was brief and precise. She expressed disappointment that agents of the federal government had violated the constitutional protections they'd sworn to uphold. She called for a thorough investigation and meaningful accountability. She noted that if this could happen to a federal judge, what was happening to ordinary citizens who lacked her resources and platform? That last line hit like a hammer, because everyone paying attention knew the answer. This wasn't an isolated incident. It was simply the one that happened to someone with the power to fight back. The political fallout was immediate. Congressional committees announced hearings. Immigration advocacy groups filed complaints. The Judicial Conference issued a statement of concern. And quietly, behind closed doors, officials began discussing settlement numbers that made budget officers wince. But the most significant development came from an unexpected direction. Other judges started coming forward. Not publicly, but through official channels. Reporting incidents where immigration enforcement had overstepped. Cases where warrants seemed questionable. Situations where agents had been overly aggressive. Suddenly, the floodgates opened, revealing a pattern that had been invisible when viewed as isolated incidents, but became undeniable when examined collectively. A task force was assembled within 48 hours of the initial incident. Its mandate was simple: review every immigration enforcement action in the district for the past 3 years. Look for patterns. Identify problematic practices. Recommend systemic changes. The preliminary findings were staggering. Hundreds of questionable stops, dozens of warrantless entries, multiple cases of mistaken identity. And woven through everything, a disturbing pattern of targeting that suggested bias wasn't just present, but endemic. Kozlowski, Bannister, and Gutierrez found themselves at the center of a scandal far larger than one botched operation. Their case files were being examined, their previous arrests questioned. Complaints that had been dismissed were being reopened. Defense attorneys were filing motions in cases the three had worked, arguing that if they'd violated a federal judge's rights so flagrantly, what had they done to defendants who couldn't fight back? The answer to that question would eventually destroy dozens of prosecutions and lead to multiple case dismissals. But that revelation was still weeks away. For now, the three suspended agents sat in their homes, watching their careers disintegrate on cable news, finally understanding the magnitude of what they'd done. Judge Forrester returned to the bench exactly 1 week after the incident. She made no public statements beyond her initial response. She simply showed up, put on her robes, and began hearing cases. But everyone in that courtroom understood something had fundamentally changed. The quiet authority she'd always possessed now carried an edge. A reminder that justice wasn't abstract, that rights mattered, that no one, regardless of their badge or authority, was above the law they'd sworn to uphold. The settlement negotiations began 3 weeks later in a windowless conference room that felt deliberately designed to drain hope from everyone who entered. Judge Forrester's attorney, a woman named Diana Pacheco, who'd built her reputation dismantling government overreach, sat across from a team of 4 federal lawyers who looked like they'd aged a decade in 3 weeks. The government's opening offer was insulting. $200,000 and a formal apology. No admission of wrongdoing, no policy changes, just money and words designed to make the problem disappear quietly. Pacheco didn't even respond. She slid a folder across the table containing documentation of every constitutional violation, every procedural failure, every moment of that morning cataloged with legal precision that made the federal attorneys physically recoil. Then she stated Judge Forrester's terms. $7 million. Public admission of constitutional violations, immediate termination of all 3 agents involved, comprehensive reform of immigration enforcement protocols, mandatory retraining for every agent in the district, and an independent monitor to oversee compliance for 5 years. The lead federal attorney, a man who'd spent his entire career defending government agencies, actually laughed. He said the terms were absurd, that no court would ever award such damages, that they'd see her at trial. Pacheco smiled. She said that was perfectly fine because discovery would be fascinating. She'd subpoena every operation those 3 agents had ever conducted, every arrest, every warrant application, every incident report. She'd depose their supervisors, their trainers, everyone who'd signed off on their methods. And she'd do it all in public proceedings, where journalists could attend and cameras could record. The laugh died, because everyone in that room suddenly understood what a trial would mean. Not just embarrassment, but exposure of systemic problems that went far beyond one judge's violated rights. The task force findings would become public record. Defense attorneys would use the information to challenge hundreds of cases. The entire enforcement apparatus would be scrutinized in ways that could cripple operations for years. 2 hours later, the government's position had shifted dramatically. $5 million, admission of procedural failures, termination of 2 agents, suspension for the 3rd. Some policy reforms, details to be negotiated. It was progress, but not enough. Judge Forrester had made clear she wasn't interested in symbolic gestures. She wanted structural change that would protect the next person who wasn't a federal judge and couldn't fight back. The negotiations continued for 6 more sessions over 4 weeks. Each meeting brought incremental movement as the federal team realized they weren't negotiating with someone who needed the money or feared the fight. They were dealing with someone who understood power, precedent, and exactly how much damage this case could inflict if it proceeded. The final settlement, reached on a Friday afternoon when everyone was exhausted and desperate to end this, exceeded even Pacheco's initial demands in some areas. $6.2 million. Full public acknowledgement that constitutional violations had occurred. Immediate termination of all 3 agents with forfeiture of pensions. Complete overhaul of warrant procedures and enforcement protocols. Creation of a civilian oversight board with real authority. Mandatory bias training every 6 months. And perhaps most significantly, establishment of a victim compensation fund for anyone who could demonstrate they'd been subjected to similar violations. That last provision opened a floodgate. Within 3 months, over 200 claims had been filed. People who'd had their homes entered without warrants. Families separated based on mistaken identity. Citizens detained for hours because they looked foreign or spoke Spanish. Each claim was investigated. Many were substantiated. The compensation fund, initially allocated at $2 million, eventually paid out over $12 million as the scope of the problem became undeniable. Kozlowski, Bannister, and Gutierrez lost everything. Their careers ended in disgrace. Their pensions vanished. Their names became synonymous with constitutional violations in legal textbooks and training materials. Kozlowski filed for bankruptcy within 8 months. Bannister moved to another state and worked warehouse jobs under a different name. Gutierrez faced additional criminal investigation when it emerged he'd falsified details on warrant applications in previous cases, though prosecutors ultimately declined to file charges due to complexities around qualified immunity. But the real earthquake hit when the task force released its full report. 400 pages documenting systematic failures across the entire district. The findings were devastating. Immigration enforcement had operated for years with minimal oversight, inadequate training, and a culture that prioritized arrests over accuracy. Agents routinely made assumptions based on appearance. Warrants were rubber-stamped without proper review. Complaints were dismissed without investigation. Supervisors rewarded aggressive tactics without questioning methods. The statistics told a story that couldn't be denied. Latino citizens were 4 times more likely to be stopped than white citizens in similar circumstances. Warrant applications for immigration enforcement had approval rates exceeding 98%, compared to 73% for other law enforcement warrants. Mistaken identity cases had increased 40% over 3 years, and complaints about agent conduct had been filed at triple the rate of other federal agencies, yet disciplinary actions were rare. Congressional hearings began 2 weeks after the report's release. Judge Forrester was invited to testify. She declined, maintaining judicial propriety, but submitted a written statement that was read into the record. It described her experience in clinical detail, then posed a question that dominated news coverage for days. If this could happen to a sitting federal judge in her own home, with resources and knowledge to fight back, what was the true scope of violations against ordinary citizens who lacked those advantages? The question haunted everyone who heard it, because the answer was emerging through the compensation fund claims, through reopened cases, through stories that had been buried or ignored finally being told. A grandmother detained for 3 hours because she spoke limited English while waiting for a bus. A construction worker arrested at his job site based on an anonymous tip that proved false, losing his employment and unable to find new work because of the arrest record. A college student held overnight because her student visa had expired 2 days earlier, missing final exams that derailed her academic career. A family whose home was raided at dawn based on faulty address information, their children traumatized and their belongings destroyed. Each story represented a life disrupted, dignity violated, constitutional protections ignored. And each story had happened while supervisors looked away, while oversight failed, while a system designed to enforce immigration law had become something else entirely. Something that treated certain people as inherently suspicious based on nothing more than appearance or accent. The policy reforms that emerged from the settlement reshaped immigration enforcement across multiple districts, not just the one where Judge Forrester lived. Warrant applications now required detailed evidence, not vague tips. Home entries demanded supervisory approval and documentation of exigent circumstances. Mistaken identity protocols were established to prevent situations like Judge Forrester's. Body cameras became mandatory for all enforcement actions, and civilian oversight boards gained authority to review operations and mandate changes. Critics argued the reforms handcuffed legitimate enforcement efforts. Defenders pointed to the compensation fund claims as evidence the reforms were desperately needed. The debate raged in political circles and cable news, but on the ground, something fundamental had shifted. Agents now understood there were consequences for constitutional violations. Supervisors knew oversight bodies had teeth, and citizens, particularly those in immigrant communities, learned they had recourse when their rights were violated. Judge Forrester never spoke publicly about the settlement beyond a brief statement expressing hope that the reforms would prevent future violations. She returned fully to her judicial duties, her calendar packed with cases, her decisions as measured and precise as ever. But those who appeared in her courtroom noticed something. When prosecutors presented evidence from questionable stops or searches, her questioning became surgical. When defendants raised constitutional concerns, she listened with intensity that made attorneys on both sides nervous. When immigration status became relevant to a case, she demanded documentation and proper procedure with zero tolerance for shortcuts. She had become, without ever stating it explicitly, a living reminder that rights mattered and that violations carried costs far beyond immediate inconvenience. The transformation in her courtroom became a quiet revolution that lawyers learned to navigate carefully. defense attorneys started citing her rulings in other jurisdictions, creating precedent that spread like ripples across legal waters. Prosecutors complained privately that she had become biased, that one bad experience had warped her judgment. But those complaints never gained traction because her decisions were legally sound, meticulously reasoned, impossible to successfully appeal. What they didn't understand was that Judge Forrester hadn't changed her legal philosophy. She had simply stopped assuming good faith where evidence suggested otherwise. She had stopped giving law enforcement the benefit of doubt when that benefit had been weaponized against citizens. She had learned firsthand that constitutional protections meant nothing if courts didn't enforce them vigorously. 3 years after the settlement, a case appeared on her docket that brought everything full circle. Immigration enforcement had detained a man outside a grocery store, claiming he matched a deportation warrant. The detention lasted 6 hours before they realized the warrant was for someone with a similar name but different birth date and physical description. The man sued for violation of his Fourth Amendment rights. The government moved to dismiss, arguing qualified immunity protected the agents from liability. Judge Forrester denied the motion in a 23-page opinion that became required reading in law schools. She systematically dismantled the qualified immunity defense, pointing out that clearly established law prohibited detentions based on name similarity alone. She noted that the agents had access to photographs, fingerprints, and detailed physical descriptions, but chose not to verify identity before depriving someone of liberty for 6 hours. She described the detention as not merely negligent, but deliberately indifferent to constitutional requirements. The opinion went further. She analyzed patterns in the agency's detention practices, noting statistical disparities that suggested targeting based on appearance rather than evidence. She cited the compensation fund data from her own settlement, showing this wasn't an isolated incident, but part of systemic problems. She concluded that qualified immunity couldn't shield agents who ignored obvious constitutional requirements in pursuit of enforcement efficiency. The government appealed immediately, but the appellate court affirmed her ruling in language that echoed her reasoning. The Supreme Court declined to review the case, letting the opinion stand. Within months, it was being cited nationwide, making it substantially harder for agents to hide behind qualified immunity after questionable detentions. But legal victories on paper didn't erase the human costs already inflicted. The compensation fund kept processing claims years after the settlement, each one documenting damage that money couldn't fully repair. A woman who lost her job after a 3-day detention based on mistaken identity and couldn't find equivalent employment afterward. A man whose children were placed in emergency foster care when he was detained, creating trauma that required years of therapy. A family whose immigration applications were denied because an unlawful detention created a false arrest record that authorities refused to expunge despite court orders. The fund administrators documented everything, creating a record that advocacy groups used to push for national policy changes. Congressional hearings featured testimony from claimants, their stories broadcast into homes across the country. Legislators who had previously defended aggressive enforcement tactics found themselves confronted with constituents who had been swept up in operations that violated basic rights. Proposed legislation emerged requiring warrant specificity, limiting pretextual stops, mandating verification procedures before detention, creating independent review of enforcement operations. The bills faced fierce opposition from those who claimed they would cripple border security and immigration enforcement. But the opposition couldn't explain away the compensation fund data, couldn't dismiss the federal judge who had experienced violation firsthand, couldn't ignore the mounting evidence of systemic abuse. Judge Forrester never testified at those hearings, maintaining her judicial role by staying out of legislative debates. But her settlement, and the reforms it generated, became the framework for proposed changes. Advocates cited her case as proof that no one was immune from enforcement overreach, that constitutional protections had eroded to dangerous levels, that systemic reform wasn't just necessary, but urgent. The agency that had raided her home underwent leadership changes, though officials insisted those changes were unrelated to the settlement. The new director implemented training programs emphasizing constitutional limits and individual rights. He created an internal review office with authority to investigate complaints and recommend disciplinary action. He established protocols requiring supervisory approval before home entries and verification procedures before detentions. Critics noted these were essentially the reforms mandated by Judge Forrester's settlement, just repackaged as internal initiatives. The director never acknowledged that connection publicly, but agents understood the message. The old approach had generated massive liability, destroyed careers, and created political backlash. The new approach prioritized doing enforcement work correctly over doing it quickly. Yet resistance persisted at ground level, where some agents viewed the reforms as obstacles rather than safeguards. Anonymous surveys revealed significant percentages believed constitutional restrictions made their jobs impossible, that oversight mechanisms were designed to punish rather than improve performance, that the settlement had empowered people who deserved scrutiny to avoid accountability. Those attitudes ensured that violations continued, though at reduced frequency and with greater consequences when discovered. The oversight boards established by the settlement investigated complaints aggressively, sustaining discipline that previous systems had dismissed. Agents learned that body camera footage would be reviewed, that supervisors would be questioned, that claims of good faith wouldn't automatically shield them from accountability. The cultural shift took years to solidify, resisted by those who preferred the old approach, where enforcement priorities trumped individual rights. But gradually, through disciplinary actions and training and leadership changes and legal defeats in cases like the one Judge Forrester decided, a new normal emerged. Not perfect, not without ongoing problems, but fundamentally different from what had existed before a federal judge experienced firsthand what countless others had endured without resources to fight back. Judge Forrester's career continued with distinction, her rulings respected even by those who disagreed with specific decisions. She never sought publicity about the settlement, declining interview requests and speaking invitations that would have given her a national platform. She preferred to let her judicial work speak for itself, writing opinions that shaped law and protected rights without fanfare or self-promotion. But in immigrant communities, in civil rights organizations, in law school classrooms, her name carried weight beyond her judicial decisions. She represented something powerful, the idea that justice could prevail even against institutional indifference, that constitutional rights meant something, even when enforcing them was inconvenient, that one person with resources and determination could force systemic change that protected thousands of others. The settlement she negotiated created frameworks that spread to other jurisdictions, other agencies, other contexts where government power threatened individual liberty. Oversight boards using her model appeared in cities across the country. Training programs incorporated lessons from her case. Lawyers arguing against qualified immunity cited her opinions. Legislators crafting reform proposals used her settlement as a template. 5 years after agents burst through her door at dawn, Judge Forrester sat in her chambers reviewing case files as always. Her routine restored, her life returned to the careful order she preferred. But outside those chambers, the impact of what she had endured and how she had responded continued spreading, protecting people who would never know her name, but benefited from the systems she had forced into existence. That legacy mattered more than any single ruling she would write, more than any case she would decide. It proved that accountability was possible, that constitutional protections had meaning, that violations carried costs beyond immediate inconvenience. Sometimes, justice required someone with power to experience powerlessness, with authority to face its abuse, with resources to fight back in ways others couldn't. Judge Forrester had become that person not by choice, but by circumstance, and she had used that position to force changes that rippled far beyond her own experience, protecting rights that belonged to everyone, regardless of status or background or ability to defend themselves. The evening news still runs stories about immigration enforcement. Political debates still rage about borders and security and who belongs where. But in one federal courthouse, in courtrooms across the district, in oversight board meetings and training sessions and policy discussions, something fundamental has shifted. Because 3 agents made a catastrophic choice on a quiet residential street. Judge Diane Forrester never wanted to become a symbol. She wanted to eat dinner with her sister, laugh about her grandson, enjoy an ordinary evening in the home she'd worked her entire career to afford. Instead, she became the case study that proved what advocacy groups had been saying for years: that enforcement without accountability becomes tyranny. That badges don't grant permission to violate rights. That power unchecked will always find vulnerable targets until someone forces consequences. The compensation fund that emerged from her settlement has paid out millions to people whose stories would otherwise have disappeared into bureaucratic files and dismissed complaints. Each claim represents a life disrupted, dignity violated, constitutional protections ignored, while systems designed to prevent such violations looked the other way or actively enabled them. Those systems have changed, not completely, not perfectly, but meaningfully. Warrant applications now face scrutiny that would have prevented the raid on Judge Forrester's home. Oversight boards have authority that makes agents think twice before cutting corners. Training programs emphasize rights protection because the alternative costs careers and generates massive liability. Body cameras document encounters that previously existed only in disputed accounts, weighted toward those with badges. These changes didn't happen because officials suddenly discovered constitutional principles. They happened because one violation targeted someone with resources to fight back, knowledge to challenge procedures, platform to force accountability. They happened because a federal judge experienced what countless others had endured and refused to let it pass quietly into settlement agreements that buried truth beneath confidentiality clauses. The three agents who destroyed their careers that evening probably still don't fully understand what they did wrong. They followed procedures they'd used countless times before. They acted on intelligence they'd been trained to trust. They applied force they believed their authority permitted. The only difference was their target had power to respond. And that difference ended everything they built. Their careers became cautionary tales used in training sessions worldwide. Their names appear in legal textbooks as examples of what not to do. Their actions generated reforms that reshaped immigration enforcement beyond anything they could have imagined while standing on that porch demanding entry without legal justification. Judge Forrester sits in her chambers today reviewing case files, writing opinions, conducting the careful work of justice that fills her calendar. She doesn't talk about what happened beyond that initial statement years ago. She doesn't need to. Her judicial decisions speak clearly about what she learned, what she values, what she will no longer tolerate from those who wield government power against vulnerable populations. The question she posed during congressional testimony haunts everyone who heard it. If this could happen to a federal judge with resources and knowledge and institutional power, what happens to ordinary citizens who lack those advantages? The Compensation Fund answered that question in painful detail, documenting violations that would have remained invisible if one person hadn't experienced them firsthand, and refused to accept that such treatment was normal or acceptable or just the cost of living in communities targeted by aggressive enforcement. 3 agents lost their careers. 1 judge gained a platform. Thousands of people gained protections they didn't have before. The balance sheet doesn't make the violation right or erase the damage done, but it proves that accountability is possible when systems are forced to function as designed, when oversight has real authority, when consequences extend beyond the immediate victims to those who committed violations. The dinner table on Sydenham Avenue has hosted many meals since that evening, when pounding interrupted laughter and conversation. The front door was repaired after agents broke through the chain lock. Life returned to normal routines and quiet evenings. But the impact of what happened there continues spreading through legal systems and policy frameworks and training programs that exist because one federal judge refused to let constitutional violations disappear into settlement silence. That refusal matters more than any individual ruling she will write. It transformed personal violation into systemic reform. It proved that rights mean something when institutions enforce them vigorously. It demonstrated that power without accountability will always find targets until someone forces consequences that make violations too expensive to continue. Justice doesn't always prevail. Systems often protect their own at the expense of those they're meant to serve. But sometimes, when circumstances align and someone with resources fights back and evidence is overwhelming, change becomes possible. Judge Forrester's case represents that rare alignment, that moment when accountability pierced institutional indifference and forced reforms that protected thousands who would never know her name, but lived safer because she refused to accept that violations were simply how things worked. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.